I think there are really two dangers that we face when it comes to thinking about the charter, and that's to think about the charter in a superficial way. We have rights and freedoms, yes, but we also have duties and responsibilities as well. And that's really what I think the heart of Section 1 gets at.
Hello, everybody. My name is David Craig. I'm filling in for Leon today on Return to Reason. I'm excited to be chatting with lawyer Kristopher Kinsinger. He's the National Director of the Runnymede Society, adjunct lecturer, and also a prolific legal columnist. He's got great thoughts on the constitutional health of Canada, the precedent-setting cases that's happened during COVID over the last few years, and also what you should know as a citizen of Canada.
Today, a special episode of Return to Reason, where knowledge and wisdom intersect.
Well, Kristopher, it's so great to have you. Appreciate you joining us. I'm just wanting to talk a lot about what's going on in our country, specifically in regards to our Constitution and Canada. Just to jump right in, pre-COVID, so let's get back to before March or February of 2020. From my understanding and from what I was hearing, not many people talked about our charter. Not many people really were aware or wasn't a hot topic. Since then, fast forward through all of COVID, the 2 years of that, plus also you look at what was happening in January and February of this year with like Freedom Convoy that went to Ottawa. There's been a lot of chatter, hot topics regarding our freedoms and what the charter, how it protects them, how there might be, and some people might categorize as maybe some loopholes. But you mentioned in your National Post article that far too many Canadians hold a superficial understanding of their constitutional rights and freedoms. Can you bring some clarity to what you mean by that?
Absolutely. And yeah, I think I would agree with your statement, David, that pre-COVID, the charter wasn't necessarily front of mind for a lot of Canadians.
Yeah.
Certainly those of us in the legal profession or academy, if you might call us law nerds, we definitely care about this more than the average Canadian off the street. But at certain points in our history, the charter has become more important to us. It's always important, but it becomes more front of mind, and we realize just how important the charter is and the protections that it provides, how important that is as well. But when I was getting at my National Post piece is that I think there are really two dangers that we face when it comes to thinking about the charter, and that's to think about the charter in a superficial way. And we can do this in one of two ways, David. The first is when we are superficial about the rights and freedoms themselves, and we look to these rights and freedoms in a very absolutist sort of way. So we can look to something, for example, like freedom of expression, and hold to this absolutist conception of freedom of expression in which any limitations that are placed on that freedom we see as being inherently unreasonable.
Yeah.
But of course, the other danger is to look at any limitation that is placed on those freedoms in the name of in the name of reasonable limits in a free and democratic society, which is the standard that is set by Section 1 of the Charter, to look at those in a way that itself is very superficial.
Yeah.
And to act as if any limitation that is placed on those freedoms in the name of a free and democratic society is somehow itself reasonable. And really where we want to be is somewhere in the middle. And we need to recognize that in our tradition, and we've inherited much of our tradition from the British tradition, in some ways more than the American tradition. Yeah. We have rights and freedoms, yes, but we also have duties and responsibilities as well. And that's really what I think the heart of Section 1 gets at. And so we need to get to this point where we don't take those freedoms for granted, where we jealously and zealously guard them. But at the same time, we recognize that this is part of what it means to live in a free and democratic society, that there are going to be times when those freedoms have to give way to other interests.
It's interesting that you brought up the duties and responsibilities, because I personally believe that that is a massive part that isn't talked about enough when it comes to our Constitution, is that if you have, as you mentioned, absolute freedom, the ideology of just absolute freedom with no parameters, which duty and responsibility, even just as human beings, can offer parameters to that freedom, you could argue that that pure freedom can lead to anarchy if you're putting aside all of these freedoms and duties and responsibilities.
100%.
You mentioned that there seems to be a rot in our constitutional culture. You alluded to it a little bit in what you're just mentioning, but can you expand upon that?
Yeah, absolutely. And I think really when I'm talking about this, Rod, it is one of culture, and it is one of how we understand what the charter is and the role that it plays
Yeah.
in our legal order and in our society. And so I think we saw this particularly, you talked about the Freedom Convoy in Ottawa this past February. That was something where that very much came to the fore, where we had people who were coming to Ottawa who frankly held very absolutist conceptions of their freedom and acted as if any limitation on their freedom, again, was inherently unjustified. But then you also had those who were responding to the concerns that were raised by participants in the convoy simply by reciting Section 1 as if that itself was the end of the discussion. And so the problem that we face when it comes to the charter is a cultural one, and we need to get to a culture that recognizes the importance, as you were just discussing there, David, of responsibilities as well as rights and freedoms. And we can talk a lot about the precise legal limitations, and certainly constitutional law is a notoriously tricky area of law. And so where we draw those boundaries is not always going to be clear cut. But more than that, we can't have law without having a healthy underlying constitutional culture. And so I think a lot of this comes down to just lowering the temperature a little bit in some of these conversations, to think about, to recognize that there is room for reasonable disagreement, but also to think about how we need to balance rights and freedoms with other values and priorities in a free and democratic society.
Let's chat a little bit about Section 1 of our charter, because there seems to be a lot of different interpretations from it. I've got friends who are politicians that have used the term, it can be used as a get out of jail free card. We've got people as well that think that our charter is written the same way that the U.S. Constitution is written, and there's obviously some very big differences. So Section 1 has been brought up a lot lately, meaning that we have our guaranteed rights and freedoms, but if there's reasonable justification to stop those for whatever certain reason, obviously I'm paraphrasing at this point,
yes,
that can be executed. Can you talk a bit about how we define reasons to stop those rights and freedoms? How can we find balance in that so it's not one extreme or the other?
Essentially, Section 1 both activates the rights and freedoms guaranteed in the Charter. So it says that the rights and freedoms that are set out in the Charter are guaranteed.
Yeah.
But then it lays out the standard by which those rights and freedoms can be limited. And the standard is what we call demonstrable justification in a free and democratic society, which is a bit of a mouthful. But what it essentially means, demonstrable means that the state bears the onus of proving on the basis of evidence that limitations on rights and freedoms are justified in a free and democratic society. Part of the problem, I think, and this goes back to the problem with our constitutional culture, is that when we talk about Section 1, there are some who certainly, perhaps without intending to, but they do look to it as some sort of maybe not quite a get out of jail free card, but really giving the government a wide latitude to place limitations on rights and freedoms. And certainly to an extent it does that. But the issue there is that Section 1 is more holistic than that. Mm-hmm. And what it calls us to is to ask what is justifiable in a free and democratic society. So it's not just about saying, yes, if the state has a valid interest in placing limitations on these rights and freedoms, it can do so. It actually calls us to both think about the scope of the charter rights and freedoms themselves, and then the standard that we want to hold the government to when we're limiting those rights and freedoms. And so I think Section 1 ought to set a high bar for both claimants who go to court and who assert their charter rights and freedoms, but also the government when the government wants to place limitations on those. One of the things, though, David, that you'll often hear said about Section 1, and this again comes back to this idea of having a superficial understanding of Section 1, is that it essentially says that all rights and freedoms are subject to reasonable limits. But that's not actually what Section 1 said. And this is what my friend, Professor Bird, says, is that if you look at the wording, what it says is that the rights and freedoms are guaranteed and are subject only to those limits that can be justified in a free and democratic society. Mm-hmm. But in theory, there are sections of the Charter which may never be subject to reasonable limits in a free and democratic society by their very nature. Now, these are the sections of the Charter that, thankfully, we don't often see claimed in court. Professor Bird specifically points to freedom of thought. I'm not sure how a government would actually limit freedom of thought. We would have to get into a very Orwellian situation there
for sure.
if it was going to do so. But let's say, for the sake of argument, in this hypothetical world that it could, Professor Bird suggests that in no circumstances would it ever be justified to place a limit on freedom of thought. Of course, what we're mostly dealing with charter litigation and charter disputes are rights and freedoms where it is reasonable in certain circumstances to place limitations on the exercise of those entitlements. And so the challenge that we face is knowing when the limitation is reasonable and when it's not.
When you have, and obviously the situation everyone's familiar with regards to COVID, is that you've got something that started out in early 2020 that people are very unfamiliar with. We don't know what's going on. You hear reports from different countries, and you have leaders who've frankly never dealt with anything like this. And they're bound to make mistakes, and they're doing their best to make judgment calls. Tough situation for anyone. But if you fast forward a year and a half, as more data seems to come through and you start learning and understanding what's going on, what is the process, whether someone agrees or disagrees with how different governments, whether provincials or federals, have acted? What's the process for proving or deciding whether it was justifiable? Because, and just to expand a little bit, I think everyone would come to a consensus if we knew that 5 out of 10 people are actually passing away because of something like COVID. I think everyone could be on the same way. That's a reasonable justification to limit our freedoms for people. But when you have places that are far more gray in terms of it's hard, you can't really draw a line as this is the threshold you have to cross. All that to say, what does that process look like, and where does it end up with who makes that final decision, whether it was right or wrong?
So there's a case from the 1980s called the Queen and Oaks. And this was the first major Section 1 test that laid out where the Supreme Court of Canada laid out a framework for when Section 1 can be used and the standard by which it can be used. And so there are a number of questions that we ask. The first question is whether or not the law pursues a pressing and substantial objective. So what we're saying there is, just at a base level, this has to be a legitimate state goal that the government is pursuing. And in some cases, we might say that there are certain laws that do not pursue valid objectives.
Yeah.
So I would say, for example, a law that compelled or prohibited worship outright would never be justified and would fail at that stage of the test. We then go through these other questions. So we ask whether the law is rationally connected to that objective. Usually the answer is yes. And then we really get to the meat of the matter, which is whether the law is minimally impairing. So we're basically asking, not in a overly strict way, but whether there are other ways the government could achieve the same objective without limiting the right or freedom to the extent that it has. And again, courts are somewhat deferential, and there are some good reasons for that, but sometimes they can be a little bit too deferential, in my opinion, where it's clear that there are other options available, and situations such as COVID demonstrate this, because we have different provinces pursuing different approaches to these situations, and some are able to achieve similar objectives through less rights impairing means. And then the last stage we ask about is proportionality. And again, here, I think often the focus is a little bit too skewed towards perhaps the state. My old professor at Osgoode Hall, Professor Jamie Cameron, has suggested that this might be the case, and that actually what we need in those situations is to really recognize that this stage of the Section 1 test is the last chance for rights claimants to avail themselves of their constitutional entitlements. And so the focus there needs to be on the adverse impact on the rights, rather than strictly on the benefits that the state says will come about as a result of those rights and freedoms being limited.
So, Chris, as you're talking through that process and through the steps and the tests as you've gone through, for me, what comes to mind is the issue of time. So time is obviously, all of that happens over a certain period of time. And if you have a government, and I'm not suggesting one thing or the other about current governments at all, this is just hypothetical. If you have a government that seems to, let's say, operate outside the boundaries or really push gray areas as much as they can in whatever, self-interest you want to call it. And then you have our system, which is set up to justify and to test whether it's justifiable. time seems to potentially become an issue at that point, because it seems like a government could get away with actions for a certain amount of time, potentially, before there's actual answers or response or conclusions, I should say, that are drawn. How much time, typically, COVID's expanded times for a lot of people, how much time can pass in that? I know it can be a long time. And is there ways around that potential problem of people having to put up with the consequences of their freedoms being unjustifiably messed with, and then they have to wait potentially months or years for conclusion? Do you have any comments on that?
Yeah, so really what you're getting at, David, is we're moving a little bit outside of the realm of constitutional law. We're getting into what we in law call civil procedure, where we're talking about the process of litigation itself. And civil procedure often relates to this ideal that we have called access to justice. And so we want to ensure that the courts remain a forum in which claimants can access justice meaningfully, and as you are alluding to, in a time-sensitive sort of way. So one thing that charter claimants can do when they are bringing a claim is to seek an injunction. And basically, when you have what are called temporary or interim injunctions, you have a court that is making an order before a final determination is made. So that might be in a case where a claimant says, this law is having an adverse impact on me to such an extent that the law should actually be suspended, either wholesale or, just in my case, for the duration of the litigation until a decision is made. That, in general, the test for injunctions, whether that's in cases involving the government or whether it's in cases involving private parties, it is a fairly strict test, and it is a hard test to meet. And there are good reasons for that. But that can create these challenges in charter litigation where individuals have to, if in the end courts decide, rule that their charter rights and freedoms are being unjustifiably limited, they may have to live with that until they get that ruling in hand. So that's the first issue. But the other issue, of course, as well, is that when we're dealing with things like COVID, these are often time-bound measures. And sometimes by the time you actually get to court, or sometimes you have a decision come out, the law is no longer in effect. And so really what you're getting at that point is simply a declaration, a retroactive declaration about whether the law was or was not unconstitutional. And we had a panel at this last year at Runnymede National Conference in March in Toronto, where we had some lawyers from various civil liberty organizations talking about this. And this is one thing that they discussed, was this challenge that we face, where the declaration isn't necessarily going to be as meaningful for the people who are seeking to have their rights and freedoms vindicated. So that is definitely a challenge that we face, particularly in these kind of emergency situations that are time bound.
And there is growing views with polarization of the charter, and you can see that even with how certain provinces provincial leaders maybe have been speaking or talking. For example, you look at issues that has happened with Quebec in the past in regards to how the Constitution works across all provinces and their agreement together. You've had, not that this has happened yet, but with Alberta's most recent premier, Danielle Smith, and she's made comments about fortifying Alberta and Alberta strong type of thing, and she hasn't threatened to leave. I know there's lots of growing dissent that way, but there's just this growing appetite to almost away from how the Constitution brings all the provinces and territories together. What are your views on that? Is that dangerous for our country, those type of views, or do you think it's healthy to promote? Obviously, provincial strength is a good thing, but not outside the context. What are your thoughts?
Yeah, well, I mean, obviously our Constitution, our original Constitution from 1867, lays out a division of powers between the provinces and the federal government. And so we need to ensure that that division of powers is respected and is protected. Of course, there are certain circumstances in which both levels of government might have jurisdiction over certain issues. We call those double aspect issues. And in certain exceptional cases, the federal government can use what's called the peace, order, and good government power to legislate in a way for the benefit of all of Canada. But I think it is important that as a starting point that we perhaps the exception rather than the rules, so that we ensure that the provinces are able to act within their jurisdiction. There is a reason that our constitutional framers created Canada as a federation because we have different regional interests, and we recognize that there was value from a subsidiarity perspective in ensuring that each level of government has jurisdiction over certain matters. But what I don't think helps the situation, David, is where we have certain provinces, and we've seen this, you mentioned Quebec and Alberta, and they are probably at the moment the two biggest offenders that are essentially proposing to unilaterally amend the Constitution. I think, again, this comes back to promoting a healthier constitutional culture, and I'm just going to keep beating that drum because I really think what is at the core of a lot of the problems that we face right now.
So in order to promote a healthier conversation, what can our audience who's watching and listening to everything you're saying right now, how would you encourage them to do that? And why should they care? If you can, what are your thoughts?
I think for members of your audience, David, who aren't necessarily trained lawyers or haven't gone to law school, I think it's really great if they want to educate themselves about the law and about what it does. And there are a number of groups out there that offer public resources for non-legally trained Canadians who want to know more about this. So one group which just put out an ebook that I contributed to is the Canadian Constitution Foundation, and they put out a book called Freedom Through Federalism, which talks about the ways in which our division of powers, our federal structure, can actually serve to safeguard the rights and freedoms of Canadians. Other groups, such as the Canadian Civil Liberties Association, also do public engagement, and so they have educational resources that talk about what the Constitution is, what the Charter is, and what our rights and freedoms protect. But really the key, I think, is to have to read widely when we're reading, and to read a plurality of views, because obviously these can be controversial issues. And so it's very important to make sure that we're not just listening to one singular voice that's trying to tell us what the Constitution is. We need to be thinking about this critically. And that means every time we hear a perspective offered, we need to be willing to interrogate that. And that cuts both ways. And that's a big part about Runnymede Society does, the organization that I work for, is that in law schools, we create an opportunity for students and scholars to look at the received wisdom, which has prevailed in the legal academy and profession, and to question that, not in a belligerent sort of way, but in a way that really is in keeping with the mission of higher education, the mission of the university, and to interrogate that and unpack that. But for people who, again, aren't in that environment, I would say read widely and be critical of what you're hearing, and recognize, that there are some voices out there that are trying to push an agenda. So it's always very important to be aware of what that agenda is.
So, Kristopher, I'm interested to know your thoughts on the Honorable Brian Peckford. Right now, and for a while, since January 2022, he's been traveling around talking about Section 1, because he was a part of 1982 and the writings of it. And he is basically advocating that it is not being used properly or as originally intended. Two questions for you. Question one is, do you agree with him? Question two is, do you think that this is positive or good discourse to have regarding our charter here?
So in answer to your first question, obviously, as we've discussed, I think there are problems with how we think about Section 1. I'm not sure that I would agree fully with Mr. Peckford's views. I think it's fair to say that his views on Section 1 are fairly extreme. That doesn't mean that they shouldn't be taken seriously, but my own opinion probably wouldn't be where he's at. I think we need to move away from, again, an absolutist conception of Section 1, which focuses just on limitations and also focuses on how Section 1 can serve to protect and strengthen our rights and freedoms. But in answer to your question about whether what he's doing is healthy or not, I mean, certainly I believe in free expression, and it's important to listen to those who were at the constitutional table in 1982. I think the danger here, though, David, is that we do need to be careful when we're listening to those individual voices, because when we're interpreting law, and we're interpreting constitutional law in particular, what the framers, the individual framers, subjectively may or may not have thought is a very fraught basis on which to interpret the Constitution. Because, of course, there were numerous parties that came to the table, and they had different objectives. They had different agendas. And so Mr. Peckford may have felt that this was what Section 1 was intended to do. That may not have been true for all of the other people at the table. The same goes for other sections of the Charter. You often hear this discussed in the context of Section 33. And usually people focus on specific voices when they're talking about the original purpose of Section 33. Often former Prime Minister Jean Chrétien is quoted in talking about it being used very rarely. And generally the better basis, the sounder basis, is to look at what the Constitution actually says. And it doesn't mean we read it formalistically. We have to be alive, not just to the context of the surrounding sections of the specific section that we're looking at. So we need to read the Constitution as a whole, not just the Charter, the whole Constitution. We also have to be mindful of constitutional history. This is something my colleague, Professor Ryan Alford at Lakehead University, has talked about, and he wrote this excellent book 2 years ago called 7 Absolute Rights, where he essentially charted the impulse of Canadian constitutionalism from Magna Carta in the 13th century all the way to the present. And so we need to be aware of that history, but it needs to be done in a way that uses the constitutional text as the starting point and then builds out from there. But, going back to your question, looking at what individual framers may or may not have thought can be a little bit of a fraught basis when we're doing this task of constitutional interpretation.
Well, Chris, I've really appreciated our chat. I wish we had more time to keep going because this is an incredibly deep conversation and there's a lot of ways we can take it. If our audience wants to follow you and find out more about what you're doing, learn more about all the things you're passionate about, tell them how they can keep in touch with you.
Absolutely. So the best way to keep tabs on what I'm up to is on Twitter. My Twitter handle is @KKinsinger. And so I post most of my articles and things that I'm doing there. As you mentioned, I am a contributor with the National Post, and so every few months I write op-eds for the Post, and recently I've been doing a series of videos unpacking some of the legal issues that have arisen during the inquiry by the Public Order Emergency Commission into the federal government's invocation of the Emergencies Act. So that's the best way to keep in touch with what I'm doing. And of course, show up to Runnymede Society events. A lot of our events and our conferences are open to the public, and I'd love to see you there.
That's awesome. Kristopher Kinsinger, audience, go check him out. He's got a great mind. You can keep up with all that's happening. Thank you so much for your time. Appreciate chatting. I hope we can do this again soon.
I do too, David. Thanks for having me on.
Thanks for watching Return to Reason. I'd like to read your thoughts in the comments section below and pay it forward. Share this video with someone. Hit subscribe and tap the bell icon so that you're notified every time I post a new video.